All right, guys, welcome to the TNSSA Legal Update webinar for 2025. We have exciting news because our new legislation just passed and it takes effect July 1st. So this hopefully will answer your questions about this new legislation. This will be posted, the full recording will be posted on our website for everyone to be able to view, member or not, because we really want to focus on education and making sure that this law is used appropriately and just the way that it's supposed to, so that we can all benefit from it. So with me today, I have Joe Doherty from SSA. Hi, Joe.
Emily.
And we also have Scott Zucker, who is our attorney kind of in-house that has, his team's been responsible for developing our lease agreements and legal documents for over a decade now. So thank you, Scott, for all the work you've done for us. But I'm going to turn this over to Joe so that he can kind of give us the background. And guys, if you have any questions, please put those questions in the Q&A at the bottom of the screen. If you put it in the chat, I might not see it, but questions we will try to get to as they are pertinent throughout this discussion. Okay, so Joe, you can take over.
Great. Thanks, Melissa, and appreciate the introduction and the opportunity to chat with everyone today. So just a little bit of background on how we ended up where we are. I think this will help set the table for what primarily Scott's going to present on with what actually changed in the Tennessee law. So about 3 years ago, a group of us, including Scott and Carlos Caslow and my colleague Daniel Bryant and I, were all sort of spitballing some different ideas based on feedback we'd received from members over the years about pain points that they had experienced. And it seemed that repeatedly there were the issues of, what do I do when I've sent a rental agreement to a tenant and the tenant doesn't sign? And then seemingly increasingly after the pandemic, I don't know why necessarily, but it seemed with increasing frequency after the pandemic, we saw people saying, I have tenants who are paying me, but they're causing serious problems at my facility. They're harassing my manager. They're trying to live in a unit. They have a meth lab. They're storing something illegal, and all of those examples that I'm sure everybody on this call has experienced at one time or another, or probably many more times than one. And so we started talking about solutions to come up with to solve those two problems and some other ancillary problems that we'll get to in a future Tennessee legislative session. But those were the two big ones. Mm-hmm. So last year we rolled out about 7 or 8 states to do some trial balloons on these pieces of legislation. And we mixed it up regionally, politically. So a Georgia and a California, for example, Idaho, states that are quite a bit different in a variety of ways, and trying to get footholds in various parts of the country. And as we were doing that, we were in conversations with Melissa and other state directors about bringing those successes. And in fact, last year we were successful on all of the bills. Get into exactly why I think that happened in a while, but we had a lot of success last year, and we're having a lot of success again this year working with state associations on these issues as well. So I brought those issues to Melissa and the lobbyist you all have used for a bunch of years now, Nathan Ridley, who's excellent, by the way, if folks don't know him. And we prepared the language, and Nathan and Melissa just kind of took it from there, and working with the legislature, securing sponsors, getting grassroots lobbying from the Tennessee Association. And Melissa, correct me if I'm wrong, but I think the language we had initially submitted to Nathan after we went back and forth about it ultimately is the language that is introduced as the bill, and then that just went through remaining the same the whole time. Am I remembering that right?
Yeah, we did do a lot of thinking went into it on our end, and a lot of second guessing. And because this is such a new thing, we've been used to just having the lien law itself, and this idea of bringing in a different way to terminate a lease was a little daunting for us. And yes, so we monkeyed around with the language for a bit, but ultimately, I think we ended up going back with what SSA, for the most part, had presented to us.
Yeah, and the feedback we got from the Tennessee board, and again, pat on their back for great work in working on getting that language into a good place. And then once it was introduced, it was just kind of off and running. And if I remember correctly, it passed the legislature unanimously with very little debate, which honestly, that's how it's gone in pretty much every state where we've done this. And I find it quite shocking because some places on the lien changes, and Scott can testify to this as much as anybody, and you too, Melissa. So these legislators, they really, really want to dig into the weeds of, well, what does this word mean and what does that word mean? And we didn't see any of that in Tennessee this year, and we really haven't seen much of that on these changes in other states. So fingers crossed that we can quickly get to 50 before anyone realizes that it might be something.
That would be nice.
Anyway, so yeah, that's pretty much where we are in terms of laying the table. And then this law, it's not in effect just yet. We're still about 3 weeks away, July 1st of 2025, when this will go into effect, and you can start using it then. But Scott will get into the details of what the law says and how you might need to update your rental agreement.
Okay.
Yeah, well, thanks, Melissa, for including me in this conversation, and thanks, Joe, for the work that you do for the country, and especially for the Tennessee operators. I'm amazed how you say it's easy to get these laws passed. I know they're not, but how effective it's been to update and modernize the laws. I mean, going back to you guys changing emails and advertising and towing, and now here we are with two other of these pain points that you've identified. And now the SSA has created, and the Tennessee Association with that, a solution to an operator's concerns on these two significant operational problem areas. So it's just wonderful to see. And Tennessee is a beneficiary of it. Georgia, where I am, is a beneficiary of it, although it was not as easy in Georgia. I'll bring out one distinction of notification in Georgia. They took away the email notification for termination, but allowed it in Tennessee. So you guys did a better job than we did in Georgia.
I'll have to brag about that later. That's good. Thanks.
So I think before we look at the slides and walk through the language of the two main issues, one being the enforceability of the unsigned contract and the second being the termination, is to further outline sort of the background intent of these. So let's first just generally talk about the enforceability of the unsigned contract. We know as operators that whether it's your mistake or the tenant moving in without signing a rental agreement by intention, sometimes you're in a situation, or maybe by acquisition of a property or other circumstances, you are left with a unit being occupied by a tenant who's otherwise paying his rent, but it's an unsigned contract. And what do you do about that? Because the tenant is using the benefit of the space, but you don't have the contract to rely on. So what this enforceability provision is that we'll look at in a minute allows you to validate the fact that you have a contract with your tenant by sending out the lease, and then as long as the tenant occupies for more than 30 days after the notification and continues to occupy the space. If you think about it as a logical conclusion, that means the tenant has accepted the terms and conditions of that lease. If they didn't like the terms and conditions, they had time to move out. And I think, Joe, you'd agree that's why sort of that issue was sort of an easy one for legislators, that it seems born out of fairness, that if the tenant's using the space and getting the benefit, that the contract that they're provided, if they continue to use after notification, should be enforceable against them.
Yeah, that's exactly right, Scott. And the issue that I'll bring up with legislators is what we see in everyday life. There's probably somebody on this call, or several people on this call, who in the last few days have received notices from Amazon, Netflix, their credit card company, et cetera, saying, we've updated our terms of service, and then buried in the fine print there is, if you continue to use this service, this credit card, whatever, after such and such a date, the new terms are binding on you. So I think it's just something that makes a lot of sense to people, and they think, well, okay, that's something I experience. I understand that, and as you said, Scott, someone shouldn't be able to game the system by refusing to sign a new contract.
So, question, if I can throw one in here on this, is what happens when you have tenants that have paid ahead? Maybe you've got that RV tenant or whatever that they leave town and they pay ahead for 12 months, but you've got new leases or new things that need to be enacted, earlier in the year. How does their prepayment, or does it affect the effective date of the changes in the lease?
I'm not troubled by prepayment. You couldn't change the rental rate if someone's prepaid, because you've created a contract as to what the established rate is for a period of time with the prepay. But the terms and conditions are presumably, unless the operator has turned it into an annual contract, and that's a little different. But if the term remains as a month-to-month contract, it's subject to change with 30 days notice. So we're just talking about the communication methodology and the fairness of enforceability after that notification. Essentially this: if you send out a change of terms or a rental agreement to your customer and they intentionally hide from execution of that document, does that mean that they're not bound to any of the rights of the operator at the facility because they've refused to sign the contract? That's where the unfairness comes in. And that's, I think, where the legislator said, if they're going to use the space, then they have to be bound to the terms and conditions. The prepayment would not bother me, except operators need to know they can't use this as a methodology of upping the rent if they've had an agreement on a prepaid program.
Right. Okay.
So I'm sorry, Joe. Then we can look at the language and move on. Joe, go ahead.
Yeah, I was going to suggest let's look at the language, because the language is keyed not off of continued payment, which is good because if somebody goes into the lien process or they've prepaid or whatever, it's keyed off of continued use of the space.
Okay, so let me share our screen. Can everybody see that okay?
There it is. Yeah.
Okay.
Right.
Look at that first slide. And this is the language, pretty straightforward. The occupant doesn't sign a written rental agreement. It's a revision, but that could be the agreement itself. I don't think it has to limit itself to amendments. Could be the agreement that the owner has delivered to the occupant by hand delivery, first class mail, or electronic mail. That's a big deal, the email. Then the occupant's continued use of the storage space for not less than 30 days from that date of the revision or notification constitutes an acceptance of the rental agreement with the same effect as if it had been signed by the occupant. Oh, I almost want to sing. Like, it's so easy. It's so straightforward. It's beautiful. And it really helps an operator who otherwise doesn't have a signed lease agreement. Nope, don't jump ahead.
Yeah.
All right. So that's it is what it is. It's what it says. And Joe, I mean, did you get any pushback on any of that?
Not on this one in Tennessee. You're absolutely right that the email issue became quite a big battle when we were in that committee in Georgia, but nothing in Tennessee. I actually wanted to ask you a question on this, Scott, and I hope it's a softball question. Would you say that the gold standard remains getting a signed rental agreement even with this language in place?
A great question. Absolutely. We really preach that this should not be used as the lazy approach to contract execution. I'm really glad you brought that up, Joe. First and foremost, work with your customers to have them acknowledge the rental agreement in writing. And writing could be an electronic assent by sending out the rental agreement electronically with an electronic signature response. Very easy to do these days. Absolutely. Please still work to get your tenants to sign their rental agreements. This is meant, in my mind, for the tenant who is, again, hiding or refusing to participate or cooperate in the execution of the contract. either you guys let them in by mistake without having them sign an agreement, maybe you did it in good faith, or they snuck in and they're using the space. Maybe they went through your mobile app or something and somehow got in the space, but they never executed the document. That's what this is for. Yes, you're going to reach out to them, ask them to voluntarily execute the document that they should have. But this is let's call it the last resort solution for that problem. Excellent question.
Awesome.
Let me sort of even further clarify that. Yeah, this is anyway. The best case scenario is for you working with your customer to get them to sign an agreement. Before, and whether the tenant is paying or not paying, the issue here is if you are going to seek to enforce your lien, you would want to do this first if you don't have a signed agreement so that you can validate the enforceability of your lien right against that tenant. So I said initially, a tenant who's paying, you would send this out because the assumption is they're going to continue to use and occupy the space. You would also use this if a tenant is not paying, and before you invoked your lien, you'd want to go through this 30-day notification process to have a lease in place and then enforce your lien subsequently.
Nice. I like that very clear process for getting that done. Good job, Joe. Are you ready for the next slide? Or
Sure. Yeah, let's go to the next one.
Here we go.
Okay. Now, this is, as Joel mentioned, I'm sure a little bit more clarity on this, is that there is a statutory remedy in place for all self-storage operators in Tennessee that if you have a tenant that's not paying the rent, that you have your lien enforceability remedy. And again, we don't need to go over that. We've done that, and you'll hear about that again in September, about your statutory right to enforce your lien and sell your tenant's goods after notice and advertisement for ultimately the purpose of selling the tenant's goods for a monetary default. This was triggered because we heard you, and we know that you as an operator are frustrated by tenants that are bad tenants who otherwise would pay, but you want them to leave. As Joe mentioned, they're living in the spaces. They're vandalizing the property. They're using it for unpermitted use. They're storing food in their spaces and causing rodents and infestation problems. Those tenants need to leave. And before this law, you would terminate the lease by notice pursuant to your lease agreement that allows you to terminate the lease. This is a month-to-month lease. You're hereby terminated. You must vacate. And then the tenant wouldn't leave. So you couldn't use the monetary lien sale on a terminated tenant because it wasn't about money. It was a holdover tenant. And this process, and we've broken this out into 3 slides, this process is to trigger your right to remove a tenant who has been notified of the non-renewal of their space and they refuse to leave as set forth in the statute after 15 days. And I say 15 days is the minimum. You could establish a longer period of time, but no earlier than 15 days for that. So Joe, I mean, when you're talking about this with the legislators, do they understand that this is for the situation of frustration with a non-responsive cooperative tenant?
Yeah, they did, and although the law doesn't, and we can get into this later, the law doesn't expressly say that this can't be used for a monetary default. The way we are talking about these is this language is for monetary default, and the existing lien process is for monetary default.
This is for non-monetary.
Yeah, right. This is for
behavior related. Yeah.
This is for non-monetary. The existing lien process is for monetary.
Yeah. And I'll also phrase this as, when we talk about non-monetary, it could be bad behavior, and we think of it primarily as bad behavior. And, look, we've even added tenant conduct provisions in your rental agreements to address the fact that you've got tenants that somehow are behaving badly these days, and you should have the right to terminate their tenancies and having them vacate the property, because none of us should suffer with bad tenants, separate again from tenants who aren't paying the rent. So, this is again a solution, but we also understand that sometimes you're converting your self-storage facilities into other uses. So we've talked about this for a situation where you have to give notice to your tenants that you are demolishing a building or some other situation where the use of that space has to end. Again, it's not monetary, it's just other reasons. And you've given notice to your tenant and they just won't leave. So this gives you a statutorily supported basis of notification and disposal if a tenant just won't cooperate with the end of their tenancy at a self-storage facility. So let's just walk through it. Here's the first section that talks about the termination. Occupant shall not use a facility after the owner has delivered a written notice by hand delivery, certified mail, or email, which is wonderful, of the termination or non-renewal of the occupant's rental agreement. Again, rental agreements are month to month, so this could be a notification towards the end of that, or at any period within it, but typically would be at the end of the monthly period where they are occupying. You could use this for an immediate termination, if there's criminal activity on the property, but I'd like people to use it in the thought process of a notification at the end of their standard monthly period. Such notice must provide occupant with not less than 15 days after delivery of the notice to remove all personal property from the self-storage facility. So again, termination or non-renewal, 15-day notice, seems pretty straightforward. Let's go to the next
one thing I want to point out here, Scott, is the language certified mail. So we've become accustomed over the recent past of what the statute calls verified mail, but what you're probably familiar with calling U.S. mail, a certificate of mailing, or something like that. That process will not work for these lease terminations. If you are, I pause. Sorry, getting tripped over my words here. You could do email, as Scott mentioned, but you can't do verified mail. You have to go back to the old style of certified mail. Maybe that's something we can clean up in the future, but that certified mail requirement does apply to these situations.
So on the electronic mail, does it have to be something like an R post that records the open and close and all of that of the email, or is this just standard email?
This is standard email, but even in the states that don't have the enhanced requirements that we see in some places, I still recommend that folks use a service like an R post or something else where you're able to track the emails. It's that much better to have that evidence. So it's not just kind of going out into the ether and you hope the tenant received it.
And I would focus on the word delivery here as compared to after mailing. So it assumes this is a pretty significant step because it's a very short period, 15 days. And then, as we'll see, it could lead to the disposal of the contents without further notice. So delivery suggests to me a tracking of that. And I think that's why they kept in certified mail, because I think the ability to track the mail and the delivery of this certified mail, or the email with the ability to track it, again, via third-party services like an R post. I would encourage that because I think this is a significant enough act that you should feel comfortable that the tenant actually received it.
So, and receipt is all we're really looking for, not that they've opened the email, but that it was delivered.
Yeah, delivery, there's sort of a mailbox rule in the law. If it gets to the address as provided by the tenant, that would be delivery. I mean, you could have a situation of refusal of delivery of the certified mail. Look, I mean, people don't like getting certified mail letters, so you might have some problems here. That's why I think the email is additionally important. And if you can confirm delivery through a third-party verification service like an R post, again, I think that it creates protection for the operator with regard to the delivery of the notice.
Okay. So maybe best case scenario would be to send this certified mail and also do an R post type of email at the same time. That way, if you refuse the certified mail, your email's good and you can roll with it. Okay.
Yeah, I mean, and look, I something like this I would post on the unit door as well. I think there's a lot of effort to verify that the tenant knew about this termination. Now, look, you're going to have situations again with a a tenant who's difficult and will not cooperate in acknowledging this. They can't hide from the notice for the purpose of their not allowing the owner to proceed with the removal and disposal of the property. But a court will know that you're acting in good faith when you've done all these due diligent efforts to get notice to the customer.
Right. And I think that's a good point that you just made, that this action, even though we have the ability now to do this, it shouldn't be taken lightly. We are just getting rid of their stuff. And it's much different than just holding a lien sale and letting it sell to the highest bidder. This is a much different act. And it needs to have the care and concern placed on each of these steps before you just decide to just do it.
Right. So, which brings us to the bigger question, which we'll circle back and talk about, but that this should not be used in lieu of the lien statute for monetary defaults. This shouldn't be the go-to solution for every problem with your tenant. I think this is used because it's a significant remedy. Primarily, although Joe's correct, this is not limited to a non-monetary default, but I think there's already a remedy for monetary default that's clean, concise, and strong. This should be something that operators use as the last resort relating to a tenant that needs to be terminated from the use of the facility.
And frankly, that's why the association, Joe can attest to this, that's why as an association, we held off for a year, because of the concern of the abuse of this type of remedy and how it could be really misused. And we want to make sure that it's used in the appropriate manner for the appropriate reasons. So
if we go to the next slide, this will demonstrate the reason why the Tennessee rental agreement has been updated, because the rental agreement, although it said may contain, you'll find in your updated rental agreements specific language notifying the occupant of exactly this right that the owner has to dispose of the property after this notice of termination and non-renewal. We'll go to the next section in a minute, but I wanted everyone to know that as part of the update of the rental agreement for Tennessee, not only do you have clear explanation of the enforceability of the contract after 30 days, which is the provision we just talked about a minute ago, is this provision dealing with termination rights as expressly provided in the statute, where it talks about giving the tenant notice in the rental agreement. Well, we've done that with the update to your rental agreement, as well as some other best practices updates and recommendations that we've included. You'll see this language specifically in the rental agreement now. And then maybe let's go to the third part, which is an interesting, and I'm kind of curious. I know this is the SSA's boilerplate for this termination, but it's really important in good language, is before the removal of the property, the owner may place reasonable restrictions on the occupant's use of the facility, including limiting or denying the occupant's access to the facility to remove the property outside of the owner's office hours. And we'll dig into this just a minute, but the ability, once you've sent that notice, to control the upset tenant or the tenant who is already committing a crime on your property, and you have to stand there and watch for 15 days as they continue to commit crimes on your property. The goal of this language is the fact that once the triggering event occurs with the termination or non-renewal, you get to control your property, your facility during that period while the tenant's supposedly moving out. It's not a free-for-all time for the tenant. You could have some pretty upset tenants coming to your property, vandalizing your property, destroying the unit as a result of their anger concerning the termination. So this is an opportunity for you to protect your property, your other tenants, and your facility during that 15-day period. Then the last sentence clarifies the owner may dispose of any personal property remaining at the facility after the date provided in the written notice as provided above. After those 15 days, dispose. As Melissa said, not an advertisement for sale, no bidders, but simply a disposal of the property. And disposal can include a sale. It can include donation. It can include the dumpster. It's just ultimately is the uh, removal of the property and transfer of its control outside of that of the tenant for the owner's discretion. So,
Do
Charles,
you have
I'm sorry. Go ahead, Melissa.
well, do you have a preferred method of disposal that you would encourage our owners to utilize?
I'm a fan in these situations. I may hear pushback on this, but if you're having lien sales anyway, I would probably include this in a sort of a manager's unit for bidding and sale. There's a couple of reasons why I like that. One is it takes the responsibility of the owner to clean out the unit. Now you have a bidder that will pay value for the unit and take the labor involved of removing the contents. So that doesn't say you can't sell it. And the other reason is I like the fact that you may get a market value determination of what the property is by selling it. It's ultimately abandoned property. So if disposal means the tenant is entitled to zero value, if the owner makes some money on it, then the owner makes some money on it. But for me, it's a later evidence of market value. If the tenant comes back later and sues for wrongful disposal, it would give the owner some defense as to what the true market value of that property was if the tenant came back and made a claim. So I kind of like the opportunity in these situations to do a sale. It's an interesting question. I don't know if, Joe, you have a different opinion on it. But before you answer that question, I'd love for you to go back to the fact you were able to sell this language about controlling access during that 15-day period.
Yeah.
Yeah, Scott. So the first sentence of this paragraph, you're absolutely right. It's standard language we're using across the country. And the way we explain it is to think about this in two separate issues, really. You have the issue of controlling access to the facility. And then maybe it's three. You have the issue of notice to the tenant when their occupancy is being terminated or their agreement's being terminated. You have control of the facility, and then you have disposal of the property. Those are, of course, related to each other, but they're also distinct in important ways, and especially when you're dealing with the type of people that we've been talking about on this call, where it's incumbent upon you as an owner to make sure you are protecting the other tenants at your facility, protecting your managers, if there's somebody who could cause a scene at your facility, and you need to have this right to exclude this individual from the property or otherwise control what's going on at your facility. And the other reason for this language is that many, not all, but many state statutes that talk about denial of access talk about that in the context of non-payment, where you can overlock the unit, and we're all familiar with that process. So we thought it was important to have that clarity here that this is not the typical monetary default denial of access. This is the non-monetary default denial of access, and here are the guideposts for that denial of access.
So can you unpack reasonable restrictions? Was there discussion about what constituted reasonable? Because I feel like that's a very broad word that could mean a lot of different things.
Yeah, Scott will be familiar with this Supreme Court decision where I won't reveal the basis for the case, but there's an expression, you know it when you see it, and that's kind of what I see as reasonable restrictions. And if somebody's living in a unit, it makes sense to completely exclude them. If the person has a meth lab, something like that. If the person is just one of these people who is constantly paying late and they run it up to the auction day every single month over and over again, and you just want to be done with them, you're going to treat them differently from the people in that first category that I was talking about. And it's really going to be up to the owner, as is most of this. And I think it bears repeating what we've already talked about, that owners, because you have a a wide level of discretion provided by this law and frankly by the lien law generally. You need to be judicious in how you execute that discretion and make sure that you're treating each case on a case-by-case basis and not just blanket saying that everybody's excluded and I'm only going to give them 30 minutes to get their stuff. You got to look at it case by case and be reasonable.
So if you're going to establish restrictions for, that more troublesome tenant, should that information be included in the termination notice that you send out so that you have that in writing?
That's a good question. Yes. So for folks who are familiar with the lien process, the law is very specific about what needs to be in that notice. The law is not, it requires nothing other than we're terminating or we're not renewing your lease, and here's the date that you have to remove the property. That date must be at least 15 days after delivery of the notice. Beyond that, it's kind of a blank slate. And I agree that if you are going to have restrictions on the tenant, it makes sense to include that in the notice to the tenant so that you're not giving them another reason to be upset when they show up at the facility and you say, oh, you can't get in, and I didn't mention that in the notice.
Absolutely agree with that. Yeah, this is an opportunity for you to establish the guidelines during that 15-day period based upon the circumstances of the termination. If there's someone's living in the space, you're going to have to identify that access is denied, limited to the purpose of removing the contents from the space, and they'd have to make an appointment. They'd have to be accompanied by the management to access the space. I think the law here understands and allows those restrictions, again, for the general sort of public safety aspect, as well as the safety and support of the facility, other tenants, and the property itself.
Right. And I think it's important to just remind everybody that in all of these communications that you're sending to the tenant, that's kind of your paper trail and proof that you did this process correctly. So inevitably, when you have that really angry tenant, that even though they've broken every rule you have in your agreement and they think they have a right to stay because they've paid you rent, you're going to need to have something to fall back on and show the court if there's a lawsuit that I followed every single step, spelled out everything that I was doing. Here you go. So this paperwork that the notices and some of the documentation that we have to share here in a little bit is going to be really valuable in this process.
Yeah, you've learned well, Melissa. It is all about the paper trail for an operator and the communication with their customers. We urge operators to be very diligent about keeping records relating to their communications with their customer by email, by letter, or by text even, so they can demonstrate to the court their good faith and compliance with the statute, but also just in terms of fairness that the customer knows what's happening. So, well done, counselor.
Thanks. I've listened to you for over a decade, so I should have learned something. Anything else to spell out about this, or do you want to move on to the next piece?
Well, that's it.
That's you? Okay.
That's
right. So
I think, though, that we wanted to address the fact of caution to the operators, which is what you talked about initially, was like, don't get too excited about this. That this is an arrow in your quiver. Is that the expression?
Yeah.
Right.
Is that right, Joe?
Yeah, you got that right.
Okay. Use it as you need it, not as your line of first response to a customer that is not paying you or paying late. We don't want to see property strewn out in front of a self-storage facility on a daily basis of tossing it after, simply sending a letter. I think that the implication of that, the risk of abuse of this, would end you right back in front of the legislators taking this right away. So just as the legislators trusted self-storage operators to use this for their protection, the protection of their other tenants, If there's a determination of abuse, it's going to come back to the industry, and I think that's true across the board. So use this diligently in those unique situations. I know I've said before to operators, if you have a bad tenant, just terminate them, right? Terminate the lease. And they've said, well, we're not going to terminate somebody who's paying the rent. We want the rent. So you know what? Maybe you hold your breath and give that 10-second determination of maybe not terminating the tenant as long as they're paying you, unless they're doing something criminal or dangerous or causing damage to your property. So, but that's up to you as an individual owner how you use this, but use it cautiously.
Yeah, guys, in Tennessee, I've seen lots of different lien laws around the country. And in Tennessee, I feel like we have one of the best lien laws. It is clean, it's easy to use. There's not a lot of vague things in our law where it's very easy for us to get rid of a tenant that is not paying their bills. And we want to continue to protect that. If we use and abuse this portion of being able to evict for non-monetary, and we use that in the wrong way and are just abusive in how we apply that, we run the risk of our fantastic lien law being attacked by the legislators saying, you know what, we're just going to eliminate all of we're going to make your life really hard because you're not acting in good faith towards your tenants. And we don't want to be guilty of that. I think self-storage already has a really bad rap for a lot of reasons. And we want to continue to show that we are, the actions that we take as operators are fair to us and also to our tenants and to our customers. So keep that in mind. In an effort to help keep all of this information clean and clear, Scott's group has put together a brand new lease agreement for us. They went through and, like he said, updated everything to include this new language so that your lease agreement supports what you're doing. We also, while we were at it, updated our vehicle storage addendum. We have a new permission to increase value for those limitation of value issues. There's a timeline now on the website for lien foreclosures that has been updated, and then a separate timeline for those non-monetary defaults so that we continue to keep those separated in our mind. There's an unsigned rental agreements FAQ page just to help in that process. And then there's also a lease termination notice that can help you get started on the right path to communicating that to your tenant. The only thing that does not spell out in the notice is any restrictions that you would have on their access. That would just need to be added in. And then, of course, our standard abandonment form. So I'm going to share a different screen here. Let me see.
Melissa, you mind if I jump in real quick?
Yeah, sure. Go ahead.
Sure. It's at the risk of beating a dead horse on the issue of exercising caution when you use this new remedy.
Mm-hmm.
We went back and forth quite a bit as we were developing language in Tennessee and in other states of, should we specifically limit this new remedy to certain types of default? And we didn't go in that direction because it became really difficult to say, well, this is only for non-monetary default. Well, what about the person who's repeatedly paying you late and they run it up to the auction deadline every time? Or it's only for when somebody is sleeping in a unit or whatever. So we were cautious about that for a variety of reasons, not the least of which is it just gets really difficult to have an exhaustive list. And,
right.
And then the question becomes, well, what if I'm not on that list? What's the remedy then? And it goes back to this uncertainty that Scott had mentioned earlier. So this is just another plug. I think additional context for why we ended up with the language we did, and just another plug for being judicious about how you use this remedy.
Right, exactly. So I do want to show everybody where you can access this on our website. And then we've got just a couple of questions that we can address. So if you log into the website, into your membership account, that's the only way you're going to be able to access the members only page, but this tab will show up. When you hover over that, just click on premium content and all of our information is right here. You can download the new lease agreement here. It is $0. It's set up in our store just so we can track who has downloaded it and how often it's being used through the year. There's also the storage addendum for the vehicle storage. Here's that limitation of value piece. Down here is your timelines. So all of your information is on this page along with lots of other legal updates. Your webinar from today, the recording will also go on to this page. So again, you just have to log into your account and navigate to the premium content page. So just wanted to make sure everyone knew how to get to that. A question that we have is about the unsigned leases. And it just says, if we purchase a facility and the customer never signs the lease agreement with the new company and the account goes to auction, are we legally allowed to sell the unit? So Scott, can you address this one for us?
Yeah, I mean, I think I included in the list of one of the elements of this, the basis for the provision was the acquisition reality that you may buy a facility and the tenants that are at the facility, you don't have a signed lease. You can't find it. It wasn't available during your audit. The prior owner didn't do a good job of getting signed leases. And there's nothing sort of nefarious about it. It's just you don't have a lease. So now you're sending out your new lease pursuant to your acquisition, and you're asking your tenants to sign it. You talked about, making the effort to do that, and now you have a tenant that's non-responsive, failing to sign the rental agreement, and now even worse, in lien. The best 1-2 punch that I can recommend on this is to send out your new rental agreement with the appropriate cover letter and explanation that here's the rental agreement, we've acquired the property, glad to have you as a customer, please sign and return. But if you continue to occupy the facility after your unit after 30 days, it's going to be deemed enforceable. Once that's in place, you've met the first step to me of the intent of the legislative statute regarding the lien, is that now you've given them notice of the lien because it's in your rental agreement, and now you can go through the process of invoking the lien enforcement. I would not jump to lien enforcement with the non-existent rental agreement. I think that it could create problems. I know it's done. It's not that it's wrong, not that it's not enforceable, but if you have the opportunity, especially with a law like this, to get an enforceable contract and then use that enforceable contract to establish the lien and then trigger the lien and sell the contents, makes my job easier and protects you guys as operators.
Exactly. Okay, so everybody needs to log into their membership account, go download the new lease, get that in place, and that will eliminate lots of issues moving forward because you'll be able to do evictions and have your the conduct information in there. I know that you guys have added about those bad behaviors. So take a look at the lease. It's worth the update. It's worth rolling this out to your tenants. I promise it's something that we need to be doing every year, is reviewing our lease anyway and making sure that all of those pieces are in there. And Scott's group does a fantastic job of keeping us up to date. So as part of your membership, that is free to you. So please take advantage of that piece. But I think that wraps up our webinar today. Guys, thank you so much for taking a few minutes to share this information with us. And we look forward to hearing more legal information from Scott's group at our fall conference in September.
Thank you, Melissa. Thanks, Joe.
Thanks, Melissa. Thanks, Scott.
Thanks, guys.